Welcome, everybody. As she said, my name is Joe Davis. I've been an attorney for a little more than 25 years. Most of that time has been spent in courtrooms trying cases, and my practice is now exclusively family law, divorces, child custody, and family law related matters. Just as we begin, I want to make a couple things clear to everybody. One is that I'm here today to provide a general overview, courtroom procedures, some basic general information. I'm not becoming your attorney by standing here and talking to you today. I cannot give case-specific advice. I can't sit down with you for a half hour afterwards and run through your specific fact pattern and provide legal advice to you. If you are looking for legal representation, if you're not able to afford a private attorney, the Center for Nonprofit Legal Services has excellent resources available for you. Mr. Churba, who's here, is an excellent attorney and a valued colleague. They do have very limited capacity just because of the overwhelming demand. The Oregon State Bar also has a modest means program where certain attorneys will sign up to provide services at reduced rates in certain cases. So all of those are things to think about, but the biggest takeaway from this is you're not establishing attorney-client privilege with me here today. This is a public environment, and I'm here to provide general information. With that said, I'm going to cover some of basic courtroom do's and don'ts with a focus on getting through witness examination and exhibits and how to get those into evidence. But to begin with, one of the most important things for creating the type of impression that you want with the judge is to maintain professional courtroom behavior and decorum. Number one is dress appropriately. You don't have to be in a suit or a business suit, but you don't want to be in a t-shirt with something offensive or potentially offensive written across the front. If jeans and a okay blouse are how you prefer and you feel comfortable, that's great. But you want to at least create an initial impression that you realize you're in court, that it's serious, and that this is a professional environment. Respect the judge and the court staff. To the judge, it's your honor. The court staff that's in there working, they deal with hundreds and hundreds of unrepresented parties every month. Be courteous to them. Understand that every case is the most important case to the person who's involved in it, but that court staff are dealing with an incredible caseload of different matters. If for some reason you're calling into the judge's chambers and speaking with the judge's judicial assistant, be nice to that person. They work with that judge every single day. Losing your cool, even though it's an emotional time to be involved in a family law case, losing your cool with that judicial assistant is not going to get you a court date faster, and it is not going to assist you in getting a better result from the judge. So just be aware that when you're talking with that person on the phone, they are sitting about 10 feet from the judge all day, every day. Be nice to the court staff and the judicial assistants. They run this building. We as attorneys know they run this building. And but enough said on that. I would expect everybody to be courteous. To the extent that you're able to, familiarize yourself with court rules and procedures. I've had clients where I've recommended that on a day when they're not stressed, when they're not thinking about their own case, they come down and watch a hearing. Watch what other people do. Watch what the attorneys do. Consider what seems to be effective and what does not seem to be effective. It's almost impossible to take in that information when you're sitting there 20 minutes before your own hearing, going over in your head what you want to say, and you're nervous and you're in a different sort of high pressure environment. If you do have the ability to come down on a Monday or a Thursday morning and find some other family law cases that are going on when you're not highly stressed, that can really help familiarize yourself. And you can, frankly, you can see what the judges respond to and what they find frustrating to them. Be prepared and organized. And we're going to talk a little bit about how to organize exhibits so that when you're there, you're comfortable. But it doesn't do the judge any good in making his decision to say, well, I've got all these emails and I can bring them if you want. When it's the day of your hearing, that is your day. That is your day to make the record and to tell the judge what he or she needs to know so that they can make a decision. They're not going to say, well, let's take a 15-minute break so you can go to your car and see if you have the medical insurance forms that show what the premium is. Or you can try to find the mean text from a co-parent. So be prepared and organized ahead of time. This may seem like, this next one may seem like you're going to look at me and you're going to perhaps say to yourself, of course, I would never do that. But having spent 25 years in courtrooms, I can tell you that people under pressure sometimes make poor and emotional decisions when they're trying to communicate, especially about something as important as your family law case that involves your child or your financial future. Remain calm and respectful. Avoid outbursts. Avoid interrupting. Certainly interrupting the judge. Respectful behavior towards the judge, if there's an attorney, or towards the opposing party. Stay composed and focused on presenting your case. Arguing directly with the other party, even though you guys may have a long history one with another, is not appropriate and will be frustrating and distracting to the judge. Interrupting, arguing directly, emotional outbursts. I mean, obviously, it's a highly emotional thing. You're not a robot, but if it becomes an outburst, I can promise you it is not helping you get the outcome that you want from the court. The judge may say you can remain seated, but until a judge says that, stand up when you talk to the judge. Generally, they'll tell you it's okay if you remain seated, but it's a sign of respect for the court. It's a sign that you're taking it seriously, and in my experience, I think that the judges respond well to that. Be honest and transparent. If you lose your credibility with the judge, you are not getting it back. Losing credibility, trying to shade the facts a little too much, outright lie. I'm not saying anybody would do that under oath in this building, but maintaining credibility with the judge, again, is what will help you get as close to your desired outcome as you can. In my experience, the judges want to understand that this parent is a reasonable person, is somebody that is open and honest about what's going on, and that they feel that they can do business with that person and trust that person, that when they send them home with that child or when they tell them to do something, that they can trust you to do that. In this building, judges hear people every single day trying to manipulate them or mislead them, whether it's pro se litigants, in a civil case, criminal defendants, attorneys. They hear it every single day. And with that experience, I believe they have a very good sense of someone, if someone is not playing it straight with the court. So value your credibility with the judge. That's the currency of the courtroom, and would encourage everybody to keep that in mind. At the end of every hearing, at least one party, sometimes both parties, leave disappointed. Sometimes a judge ends up somewhere in the middle. Sometimes it goes all one way or all the other. It doesn't matter. The thing to remember is that family law cases span a period of time. More likely than not, you will be back in front of that same judge at some point in the future. A child gets older, and a different parenting plan is more appropriate than when you have a toddler versus an 8-year-old. Somebody wants to move, somebody gets a new job, there's a new work schedule, and you're going to come back in front of that judge. Even if you're disappointed with the ruling, again, avoid outbursts. You're going to see, 90% of the time, you're going to see that judge again. If you go and tell the judge that you think the ruling is flat out wrong or idiotic or whatever words people may choose, and I've certainly heard some choice ones in the courtroom, you should expect that judge to remember you the next time you're back in court. So, a lot of times people have questions about what's going to happen when they call me up to the table and I sit down. How do things go? The first thing is the order of affairs, the order of speaking. In the basic order, if you're a trial, you're the petitioner, you're going to get to testify first, and you're going to get to call every one of your witnesses first. Of course, subject at the end of each person's testimony to questioning by the other side. But at trial, the petitioner will always go first, the respondent will go second. If it's a motion, I don't know if any of you had to come down to these Monday or Thursday morning hearings where they deal with shorter motions. Whoever brings the motion will go first, even if you're the respondent. But that means that if you're the one who brought the motion, I want to change the parenting plan, I want to change child support, I want to change custody, I want to relocate, whatever it may be, even though you're the respondent and you may have sat at your trial and gone second, you need to be prepared to stand up, go first, tell the judge what you want and why, and not just be responding to what the other people say, but affirmatively telling your story. With that, if given the opportunity by a judge to make an opening statement, I can guarantee you every judge in this building wants you to stand up and say exactly what you want. Tell the judge what it is you are asking for. I mean, for example, I'm asking for more parenting time today and a recalculation of child support. I would like parenting time to be from Tuesday release of school until Saturday at noon. I mean, tell them what you want, because then that frames the issue in their mind. They know what you're asking. They know what you want. Standing up and saying, I want as much time with my child as possible. Okay, we all do. But that doesn't really help the judge focus in on what they need to be thinking about and what the issues are for that day, what the issue is at hand. You'll be sworn in. Usually, you will provide your own testimony first. If you want to call a witness before you testify, that's okay. Tell the judge, I'd like to call John Smith as my first witness. They'll come in. Usually people, in 80% of our cases, it's the two litigants that are there to tell their story and frequently don't have additional witnesses. But if you do, it's up to you when you can put them on first or you can put them on after you testify. I believe the judges want to hear from you as the person who's there asking for something that day. They want to hear from you first and get a sense of you and get a sense of what it is you're asking for. After you're done testifying, you should expect to be asked questions by the other side. It's called cross-examination, right? You see it on the television shows. Listen to the question and do your best to answer that question. I will say that most of us in our normal lives, in our civilian lives outside of this building, if somebody asks me a question that I don't really like, I spend maybe 10 or 15% of the time responding to that question and the other 80% of the time trying to turn it back to what I want to talk about anyway. Don't do that. Listen to the question to the best of your ability, answer the question completely and honestly, and That's the purpose. When you are cross-examining, if you have fact-based questions that you want to ask somebody after they testify on the other side, a common trap for both pro se litigants and, frankly, attorneys is to try to use cross-examination to restate everything that you think about the case. Trust me, the judges paid attention when you were up talking before, or they'll pay attention when you talk later. If you have fact-based questions, it's absolutely appropriate, and it is absolutely your right to bring them up in cross-examination. If you don't, and you really just need to tell your story, that's okay. Just because you have the opportunity to speak, don't feel as though you're on the spot and pressured and have to. But remember, cross-examination is a time to ask questions. So, just by way of basic examples, if a party were to come into court and say that there was an incident at school last Friday, appropriate cross-examination might be, were you present? Did you see this happen? Do you have a witness here today that can explain everything that happened and put it in context? Or do you only know what somebody else may have told you? Those are fact-based questions. What's not a fact-based question is to say, well, it was really no big deal what happened at school because I was there and picked up Johnny and dealt with the issue afterwards, right? Well, you're testifying. You're not asking the other person questions. But remember, if you don't have questions, it's okay. You're going to have the opportunity to tell your story. If during your own testimony, questioning your own witness, or cross-examination of somebody else's witness, if you want to offer an exhibit, if you feel as though it's time to talk about an exhibit, when it's your turn to speak, you simply say, I'd like to offer exhibit 1, exhibit 2, whatever it may be. We'll talk about how to number things here shortly. This is an email from Father to me from November 2nd. And if you want to talk about it, that's an appropriate thing to say. You're not interrupting the court. The court wants to obtain the information to get the decision. Paper exhibits, text messages, emails, school records, whatever it may be, they need to be printed out before you get to court. Nobody is going to look at your cell phone and read through the text messages up on the bench. Download them, print them out ahead of time. They need to be marked. You can get exhibit stickers here or at the windows upstairs, free of charge. If you're the petitioner in the caption, your exhibits should be numbered 1, 2, 3, etc. If you're the respondent, 101, 102, 103, and on. My practice, and I think the practice of most attorneys who do this for a living, is to mark your exhibit. So it already has the sticker on it. You number it, and then you run at least 3, potentially 4 copies of that exhibit. Because when you're standing there in court, everybody needs to be able to look at the same document while you're talking about it, which means the judge is going to want their copy. They get the one with the actual sticker on it. The opposing party or their attorney is going to want a copy of it, so that's 2. You're going to want to have a copy of it in case somebody says, well, let's look at the 3rd line of this, and everybody can look at it. And if there's a witness up on the witness stand talking about that document, they're going to need a copy. So you need the one with the sticker on it, plus 3 is my practice, so 4 total copies. If you end up with extras, fine. But if you find yourself short and you find yourself getting thrown off your rhythm in the middle of court with 15 people sitting out in the pews and a judge in a black robe looking at you and maybe an attorney on the other side, it can be frustrating. And I can tell you as a longtime professional attorney, if I have something go wrong with my exhibits in the middle of my case and and I'm scrambling around and I can't find it and I put it in the back of the file and it shouldn't have been there, I get flustered. And I've been doing this for 25 years. So be prepared. If you think you might use it, mark it and make copies. They have the stickers here and at the windows. If you're the petitioner, ask for petitioner exhibit stickers. If you're the respondent, it's a different color because it makes it easy for the court staff. If you're a respondent, ask for the respondent exhibit stickers. If you think you need 8, ask for 10. You might accidentally misnumber something. I have. No judge wants to be there in court with you now saying, well, I've got this one copy, and now I want a sticker from the court while we're all standing there. And then you're going to mark it, and then you want to look at it, and judge, you look at it. Oh, but can I have it back? I want to refer to something. You don't want to do that. The judge's courtroom time is valuable. There are a whole lot of people coming through this courthouse every day, every week, hundreds of families in crisis, and they're trying to meet everybody's needs. And if you've been involved in a family law case, you know that things can be rescheduled and things can be delayed because things take longer than expected. And I promise you the judges will appreciate it if you show up, you're organized, you have your things pre-marked. If your exhibit has multiple pages, staple it together. Don't paperclip it. Because our friendly court staff is over there on the side shuffling sometimes dozens or more pages of documents. And if you lose the second page of a document and it's floating around on the desk and the judge is looking for it, just staple it.
Mr. Davis?
Yes.
Should they number the pages on the multiple page documents?
You should. I would say I haven't seen judges I've seen judges give attorneys hard times for not saying this is Exhibit 1, page 2 in the lower right-hand corner. This is Exhibit 1, page 3. I got to say that if it's stapled, I've never seen a judge get too upset with a pro se litigant. They're usually pretty happy that your exhibit is pre-marked and you're organized. If you're really going for it, yeah, sure. It's a 3-page document, lower right-hand corner, Exhibit 1, page 2, Exhibit 1, page 3. Electronic exhibits. So much of our communication is electronic. I can tell you I have clients that run their entire parenting time, communication with their ex, arranging parenting time with the children through text messages. So, if you have text messages that you believe are relevant, you've got to get them off your phone and onto a USB plug-in drive. Then you still have to have a sticker on that USB stick. This is Exhibit 2 or 102. Then, if it's audio or video, which is frequently what people want to present that needs to be on a USB drive, you need something to play it on. The court you're not going to go plug it into the judicial assistant's computer for security purposes. You can imagine they're not letting any outside source come and touch their computers. If you have a laptop, bring it. They generally have a variety of cables that can plug right into your laptop if you want to show something on the screen. But even if you're there and you're going to play the audio out loud, you have it downloaded on your laptop, or you're going to play the video on your laptop while you're in court, you have to have the USB stick because you have to be able to give it to the judge, and the judge has to be able to keep it in case they want to review it and look at it again. And it's got to be marked.
Mr. Davis?
Yes.
Hannah,
Do parties need to provide multiple USBs like they would a standard copy of something?
I would say generally if you have one extra copy onto a USB so that the other side can have it for their file is appropriate, but it doesn't do any good to hand the witness or the judge the USB in the middle of the hearing because they're not even going to play it on. But you want it downloaded on your own and you want to be able to give it to the other side.
And Mr. Davis, the courtroom technology page on our website does have some information about scheduling a time far ahead of your hearing to make sure your equipment works. And in one of the handouts it will get.
And when we first started, maybe it's been 10 years now, but when they first started having the plugins available, readier access to screens in the courtroom, I would come over in the afternoon before a hearing or the week before a hearing and make sure that I knew how my new laptop plugged in and I made sure that it worked. So use the resources that are available. I mean, there are services here that they want it to go smoothly when you're in the courtroom. Because like I said, they're trying to process dozens and sometimes hundreds of families in crisis each month. So they want it to run smoothly. They want to facilitate you having an appropriate experience in court so that you're not, so that the judge can make a decision based on what's actually going on in your life and not based on if somebody can figure out how to make their laptop work. So text messages and emails, print it out. You're not going to look at your screen. Print it out, marked like we talked about with the sticker. Video, audio, or other electronic data that can't be printed for whatever reason. USB stick. One for the judge, one for the other side. Bring a laptop to play it and connect it to the court system. When you're trying to introduce exhibits, I talked about this a little bit. When you're ready to refer to an exhibit, pause, even if you're talking, not while the other person is talking, if they're providing their testimony, but when you're asking questions or it's your turn to speak, totally appropriate to say, I'd like to offer Exhibit 1. Like I said before, this is an email from this date between Father and me. The judge will always ask if there's any objection. If you have an objection, or if the other side has an objection, it needs to be based on some rule of evidence, a legal basis that this should not be admitted into evidence. Saying, I disagree with this, or that's untrue, is not an objection. You're going to have your opportunity to get up and say, hey, what he said about what happened at school last Friday afternoon with our child, that's not true. Here's what happened. You're going to have your opportunity. Untruthfulness is not an objection. Saying, I have a text message that you wrote me that says something different, that's not an objection. It's a credibility issue that you can raise during your own testimony or your cross-examination of the person. But that's not an objection. Witnesses must be present in court to testify. Notarized affidavits, letters of recommendation, letters of support will not be allowed. You can have it stamped by everybody in the world. Doesn't matter. If they're not there to be cross-examined, their affidavit or letter in support of you is not coming into evidence. If you have a witness that can't be there in person, well in advance of your hearing, contact the court. They may be able to appear by telephone. They may be able to appear by Zoom, what we use is WebEx, but through video conferencing. They're not going to be able to appear by video conferencing if you ask at 8:55 on a Monday morning before your 9 o'clock hearing. I would say if you think there's the possibility that they're not going to be there in person, a couple weeks in advance, you need to be contacting the court. I want to send this person a WebEx link. I want permission for this person to show up telephonically. And in general, they'll work with you and accommodate you. In very rare cases where if you're bringing in an accountant or a physician and there's going to be tons of documents that they have to go through during the trial, the judge may say, I want that person here. That's too difficult to do through a video chat to make sure we're all on the right page of the medical records. That's a pretty rare occurrence. I've certainly had plenty of accountants testify and the physicians testify through video chat. Got to do it ahead of time. Now, if the person ends up being able to be there in person, that's fine. Just let the court staff know, before the hearings begin, that that person's not going to be logging on. They're here in person. Think that you're going to need them. Don't wait. Don't show up on the day. And you do not want the judge to call that person and have it go to voicemail, or to have it go to the receptionist at their office where there are 75 employees and they're trying to track that person down. You want to have that person have the number that goes directly to them, and that they know that they need to be available that morning to take the call. Because again, courtroom time, the judge's time is very valuable. So, talk some about how to get emails and text marked. Emails, texts, or other written communications that were written by the other party are generally going to come right into evidence. This is our text message. It's between the two parties. It's coming in. If it's written by the other party and it was sent to your brother, your sister, your mom, generally coming in. Texts or emails that you sent to the child's teacher or that the pediatrician's office sent to you are not going to be coming in. And that's because that's hearsay. You can hear people say, well, it's all hearsay. So those types of written communications, you need the author of that document to say, this is what happened. You can't necessarily rely on an email from the admin staff at your child's school that something happened last Friday. So if the other side denies that they wrote that text message to your sister, to your mom, to your brother, to whomever, having that person there to say, no, we text back and forth regularly, and this came from his number, and it's the same number that I get all my texts from him, and this is what he wrote me last week. Having that person there to confirm that the text was actually sent to them is important. Now, 95% of the offensive text messages or the text messages that you really want the judge to see are between the parties, because that's where the conflict is. But if there's a circumstance where texts are being sent to a third party, if the other parent wrote that text, wrote that email, in general, it's coming into evidence. Okay? But that doesn't open the floodgates to all the world. Any email that you've ever received from your best friend in high school saying, I saw Dad at the bar Friday night at 10, wasn't he supposed to be parenting? That's not coming in. You need to have that person there to say, last Friday night at 10, I saw Dad at the bar. Okay? After you've done all of this, you've put on your witnesses. They've been questioned by the other side. They've put on their witnesses. They've been questioned by you. The exhibits have gone in. If you get to the end of all of that and you still have papers in front of you that you want the court to see, before you end, you can say, I have 3 more exhibits that I'd like the court to consider. Just because you forgot it doesn't mean you can't kind of get to the end of your time and say, wait a minute, hold on, I apologize, Judge. I've got 2 more text messages printed out, marked as exhibits, and I'd like to offer those at this time. But after all that's done, the court may ask if there's any closing argument or a closing statement, or you may just say anything further. This is not a time for you to introduce new evidence, right? To introduce new thoughts. This is a time to summarize. This is what's going on. This is what I'm asking for. And this is why. So, as I think you've seen from the testimony, Dad's not using his parenting time. I'm asking that the judgment be changed and the child support be changed so that it tracks with what's actually happening. Thank you. Sit down. Not always, but I have seen many an attorney and many the self-represented party talk themselves out of a win in their closing statement. Because they're getting angry and they're getting worked up and they've been asked maybe some pretty tough questions and they're on edge and they're gonna say their piece to somebody in a position of authority. Feel like the evidence came in, and if you've told your story, keep your cool in your closing statement. Don't veer off into the wilderness, because, like I said, I've seen many an attorney and many a self-represented party. It's not exclusive. Attorneys don't have necessarily magic. Talk themselves out of a good result. If you believe that the other side has documents that you want to see, you need to be asking them for those documents through what's called a request for production. You need to be asking for those documents 45 days, I would suggest, before your hearing date. Because under the rules, people get 30 days to respond. So if you need last year's tax return to figure out your child support, and they have it, you don't, and you don't have a tax preparer, you can go get a copy. You need to ask for it well in advance. If you think that they have school records that for whatever reason you don't have access to, you need to ask for it well in advance. So what I'm trying to communicate, though, with all of this, is it all has to be done in advance. Exhibits marked in advance. Witnesses set up for telephone testimony or for WebEx testimony in advance. Asking for documents in advance. I can promise you that even if it's two attorneys, the well-prepared attorney beats the person who thinks they're going to wing it but is slick on their feet 9 times out of 10. If you yourself feel that I get nervous, the other side, he's really good on his feet. He's a good talker. What I can promise you is that you will give a better presentation. The court will appreciate it. Court staff will appreciate it if you do all of these things well in advance. In court, the prepared party beats the good talker 9 times out of 10. Now, if you can do both, great. Go to law school. But don't lose hope because you feel like the other side has a big personality and fills up a room when they're speaking. That's not what the judge is making a decision. If children are involved, the judge is going to try to figure out which parent they trust, who they find to be credible, who they trust to take this child home and do what the judge has told people to do. And if that's you, great. If, in my experience, what I believe to be true from watching judges for a long time, is that if you can't keep your cool in a courtroom being asked some difficult questions, and if you can't avoid outbursts and arguing with the judge when you're in this pressure cooker of a courtroom, I believe the judge will have concerns about how you're going to act under the natural pressure of parenting. When you have 2 kids asleep and one has a urinary tract infection and you've got to go to the emergency room and the other parent won't help out and take the 2 kids, and you don't know what to do and the other parent won't talk to you, you're only talking to the new girlfriend and you don't have any help, that's hot. That's a pressure environment, just like the courtroom is a pressure environment. Outbursts, being discourteous, losing your cool in court, I believe, raises the specter of the judge saying, listen, I don't trust how this person's going to operate when things get tough at home and when you're really feeling up against it with kids in your care. So remember that. You want to behave in a way that builds credibility, that builds a sense of reasonableness, and that'll serve you well. Even if you don't get exactly the decision you want every time, these cases go on and on. Over time, the judges will come to remember you, and the payoff isn't always at the first hearing. Sometimes it's at the third hearing or the fourth hearing. But if you lose your credibility with the judge, it's almost impossible to get it back. Preparation beforehand, appropriate behavior when you're in court, accepting the decision without losing your cool at the end, will all serve all of you well. So what I want to do is take some time and answer your questions. But remember, I'm not going to be able to get into maybe the fact pattern of your exact case. But if you've been in court, you have experiences that you wonder why something happened, you get general information about how the courtroom operates. If you have questions about how to get documents, how to get things into evidence, again, I can provide general information. And I know that obviously I've been talking this whole time, but I want to make sure that you're getting the answers that you need so that you can feel prepared, that you can know when you walk into that courtroom that you feel ready. So has anybody here already appeared and had a hearing in court? 3 out of 4? Okay.
Is everybody comfortable with asking questions? If not, you can write them down, or you can ask Ray to cut it out of the video.
Yeah.
So if I have someone that I would like to testify in person, do I need to let the courts know in advance?
No. You don't need to let anybody know in advance. If that person is not showing up voluntarily, you can go to the windows on the first floor, get a subpoena. The court administrator will sign that subpoena. That makes it enforceable. To hand that subpoena to the person, they will need to show up. If your ex's cousin has a vital piece of information, you believe that person will tell the truth when they're in court, but they don't want to show up because they're going to get a hard time from the rest of the family. You get a subpoena at the windows, and you have somebody serve that subpoena, and they have to show up. And if they don't, you need to raise that issue with the judge and say, I subpoenaed his cousin, he's not here. We either need to come back when he's here, or I don't know what to do, Judge. And generally, the judge will take care. The judge will take care of that situation. But you don't need to provide a witness list ahead of time. With that, I will say, what the judges do not do is count up the number of witnesses on each side and go with whoever brought in more friends and family. If you've sat in there, the 3 of you that have been in court and sat in there in those Monday or Thursday morning hearings, you've seen the people that come in with their 10 or 15 person entourage of support personnel. That's okay. Every judge knows that your mom, your dad, your sister, your brother is going to get up there and say, yeah, she's a good parent. Having one witness, maybe 2 that says that is great. Having 5 people get up and say that, the judge is going to start looking at you funny. That you're, again, not respecting the value of that courtroom time. If you have people that are going to talk about different instances, I saw them at the bar Friday night. I saw them wherever, not being at practice to pick up from soccer practice. Well, sure, call as many of those witnesses as you need. But sort of the character witnesses, what you have to decide. In my practice, 1 or 2 maximum.
So my question is about the order of some things. So you've given your side and they have a counter. Where do you counter the counter, I guess?
So just by way of example, if it were you and me, I'm saying I want to change parenting time, and you make a counter that you want to change custody. Something like that?
kind of. Mine are.
But like for a basic
so,
example,
ours is very basic.
I'm going to put on my parenting time case.
Okay.
The other side will respond to my case and talk about why custody should be changed. And then you'll have the opportunity, as the first person who spoke, to have a rebuttal at the end to touch on anything new or anything that you want to respond to that they brought up as a counter.
Okay.
What I will say is that, again, 90% of the time, you've told your whole, in this case, I'm the first person that filed a motion to change parenting time. Maybe there's one or two issues that were raised that I didn't think about that I might want to touch on at the end. 90% of the stuff you've already told your story of what's going on in your life and in the child's life. And but if you need the opportunity to respond, you went first. If you feel like there were a couple points they raised that caught you by surprise, you can ask at the end to say, Judge, there's a couple points that they raised. Talk about those. Don't put on your whole case again. Just, talk about those two or three things to which you want to respond.
So we don't have any children, so ours is very basic. So we would put that response towards the end of our.
If you know what they're going to cover, deal with it right up front during your case.
Okay.
If you know what the issues are in your relationship, you know what your issues are as co-parents. If you know what everybody's beef is with each other, just cover it.
Okay.
Put it right out there.
Okay.
Make it easy for the judge. Tell the judge up front exactly what you're asking for, and put it out there. If something catches you by surprise, or they bring up something that's, like you have the text message that disproves what they say, sure, you'll have an opportunity to come back at the end.
Okay.
But I'll say it's pretty unusual, even for cases with attorneys.
Would you say using the documents that were filed as kind of your outline of how things are going to go is a good way to look at things? Like the petition, the response, so you know what you're going to talk about?
Yes. Yes, but frankly, the spaces in the form petitions have less space than what you're going to want to talk about when you're in court. So you can use those as, let's say, signposts of what you want to talk about, where it says, okay, do I want joint custody or sole custody? Okay, I need to talk about that. What do I want the parenting time to be? I wrote it down. I want to talk about that. But don't feel that you're restricted only to what you wrote down in the forms. That raises the issue to the court. It lets the judge know, I want to talk about custody. I want to talk about child support. I want to talk about parenting time. But there may be a whole lot that needs to be discussed, or that needs to be presented to the judge to provide that judge a fair opportunity to make a good decision that you didn't write down. Yes?
Some hearings go very quickly. Can you speak to how best to address if you feel like you didn't have a chance to present all of your evidence or witnesses?
That can be very difficult when something is happening fast and maybe you feel as though the judge has an impression of what's going on and it's not correct. Just like you, just like me, the judges are not magical people. They are humans. They make mistakes. They might focus on an issue over here when really everybody else wants to talk about something. It's not. It's always appropriate to stand up and say, Judge, I don't want to cause a delay, and I'm sorry if I'm taking the court off track, but I do really think that we need to discuss this incident that happened at school last Friday and the changes in the child's behavior since that day. And I don't feel as though I've had the opportunity to present that. Now, if the judge says, I'm not hearing it and I'm ruling, go sit down, there's very little you can do about that at this level. And you start talking about Court of Appeals type issues, but I don't do that. I don't know about that. But absolutely, if you feel like kind of the train is leaving the station and you haven't had the opportunity to say what you need to say appropriately, respectfully, a lot of lawyers, we apologize for things that aren't our fault. Hey, I'm really sorry, Judge, but I'd like to talk about this. That's okay. Remember that judge has something you want, right? That judge has a decision that has the power to give you what you're asking for that day. And so being respectful, being courteous, but also assertive and making sure that you have the opportunity to be fully heard is important. But waiting for the decision to come down and then standing up and saying, "You didn't even let me talk about the incident at school last Friday and how the child's behavior has changed. What's going on here?" That's too late. That's too late. But if you do feel that the steamroller is rolling or that the train is leaving the station, it's okay to take a breath, stand up and say, "Judge, I apologize, but I just don't feel that I've been able to cover these 2 or 3 issues, and I'd really like the opportunity to get this in the record." Does that make sense? It's hard to do. When that judge is up there on the bench in a black robe, looking down, and there's 25 people sitting out in the benches out there, but this needs to be a building where you can come and tell your whole story, subject to the rules of evidence. And you need to, at least win, lose, or draw, it's important to walk out feeling that you've been heard. So it's okay to kind of raise your hand and stand up and respectfully assert yourself. This is, again, I'm not doing a consultation in my office where I'm telling you what I think about your case, but I gotta believe that everybody understands the courtroom is sort of an artificial environment, and it can be a pressurized environment. And to the extent that you have questions today, happy to answer them. We have wonderful court facilitators,
Yes.
But they, like me, are not going to give you legal advice about what's happening in your particular case. But they can help you locate the correct form for what you need, talk about this is how it works, this is how you get on the court calendar, this is how you get a document served through the sheriff's office. They're wonderful at all of that. Center for Nonprofit Legal Services, the Bar Modest Means Program are all resources if you feel that just going out and retaining an attorney doesn't make sense for you. So there are resources out there. If you are walking in on your own, I promise you, you will feel better, you get a better result. If you're prepared, if your exhibits are marked, if you've got your videos and audios on a USB drive, if you've all that preparation in advance will serve you well. Yes.
If you have a hearing date and then something came up, like the judge needed to take another case, and then they can't get another hearing date that works with all the parties for another month and a half, is there anything to do within that?
The court calendar is its own machine. And that machine turns, and man, I've called, it's sort of like trying to get into the dentist. Can we get on the cancellation list? I don't really have that here. So what I frequently tell my own clients is that if I could control the court calendar, I'd already be retired. So it is a truth that the court system cannot move at the speed at which people's lives move, and at the speed that people in conflict have things going on with their kids. The judges know that, the attorneys know that, but there are hundreds of other families in crisis. There are hundreds of other families who their hearing got pushed back, thousands maybe. But there's not much you can do. That's the way it is. Court calendar is a tough one. Yes.
Can you speak to whether or not it's appropriate to bring your children to court with you?
Oh, do not. Do not bring your child. If you believe that you want a child to speak with the judge, you can ask. And it's within the judge's discretion whether or not they're going to speak with that child. In my experience, except in rare circumstances, kids under 11, 12 years old, the judge isn't going to talk to. In my practice, I am hesitant to bring children in unless there is something going on in that other house. That child is the only one that can say what's happening there, because it's a black hole of information to you. But bringing kids in to be spectators and watch their parents in conflict is harmful to the child's development and will be harmful to that child's relationship with both parents. If you need that child to be a witness, have a family friend, have a new partner, have a parent, whatever, sit with them at the other end of the hallway, out in the hallway, and if the judge wants to see them, court staff will usually come and everybody will leave the courtroom. It will be just the judge, court staff. If there are attorneys, maybe the attorneys will sit off on the side. But I urge you to consider that very carefully before putting a child in a situation where they're testifying in their parents' case. The situations where I do it is if you have a teenager that just really doesn't want to be at mom's, really doesn't want to be at dad's, and can say why. The judge wants to hear from that child. 15-year-old, 16-year-old, you know. And if you have a slightly younger child, and if there's something going on in that house, if the child is coming home and telling you, that's hearsay, the child's just telling you that that child needs to speak to. Dad's drinking 20 beers a night. Or dad takes off and leaves, and I've got to make dinner and breakfast for my younger brother. If you have a situation like that where really you have no choice and that child is the only witness, that's understandable. But don't have your kids watching conflicts between adults in court.
What about if the child writes a letter?
Just like I talked about before, they have to be there. They have to be able to answer the judge's questions or the attorney's questions. I will say the attorneys, any attorney with an ounce of sense is not subjecting a child to a rigorous cross-examination, but there might be a few things that they want to ask about. But it's, in my experience, has always been done pretty kindly and generally with sensitivity by the attorneys. But no, having the child write a letter, unless both parties agree, but they're not. You're in court for a reason. You're in court because there's a disagreement. So they got to come in.
With all the chaos and being in the courtroom and I have all my exhibits, can I have a friend or somebody sit with me at the table?
You may not. The people that come up to the table are the parties, and if they have an attorney, they're attorney. So you don't get to bring your best friend up or your mom or somebody to sit with you, child. They need to stay in the back. Generally, if somebody wants, and if somebody asks, you can make all the witnesses wait outside the courtroom. They call it excluding witnesses. The logic behind it is if you have three witnesses sitting there watching what's happening, they can kind of line up their story to what they want to talk about. But if they're out in the hallway, you're getting a more unvarnished version of events. So if you think that might happen, and if the other side shows up with four witnesses, ask that the witnesses wait outside. That's totally appropriate. I do it in every case. But no support personnel up at the table. They call it passing the bar for a reason. That bar is that rail that goes between the seating area and where the action is. And the people that get to go past that bar are the attorneys and the litigants, the parties themselves.
Anybody else have any questions?
Show up 15 minutes early for your hearing. Not pulling into the parking lot 15 minutes early. I'm talking about sitting out in the hallway waiting for them to unlock that door 15 minutes early. Somebody who shows up 5 minutes late, I promise you the first impression the judge is going to have is that this person doesn't care enough about what's going on here today to make sure they're here on time. Mondays and Thursday mornings, that parking lot is going to be packed. You might be parking across the street. You might be parking a block away. Get here early with your prepared materials, like we've talked about. I'm going to sneak it in one more time. You'll be settled. It's good for you. You're here. You have a few minutes. You might walk the hearing before you, see how it goes. But under any circumstance, showing up late is an indication to the court that you don't care enough about what's going on to even show up on time. If you have kids involved in your case and you're not showing up on time, the court is going to draw an inference from that. It's not going to be in your favor.
I have a question. If you have two people that you know that are married and you know you're going to have to subpoena both of them, can you have one of them stay outside of the courtroom while the other one is okay?
If you're concerned about that, like one seeing what the other says or them kind of lining up their so just ask it all at the beginning, just at the very beginning, stand up and say, Judge, before we get started, I'd like to ask that any witnesses that might testify wait outside. And then you just go out to the door and call them in one at a time when you want them to come in. But totally appropriate. It's not a weird thing to do. It's not an imposition to the judge. It's an everyday occurrence is to exclude the witnesses. Sometimes people don't care. You know, there's a couple people in there and they're going to watch and nobody's that worried about it. But my practice is to always have the witnesses wait outside because I'm always concerned about somebody shading their testimony based on what somebody else has said. In fact, their husband and wife doesn't matter.
Yeah.
Okay? They may be a team in a lot of ways, but everybody testifies by alone.
I have a question. What is the easiest way to get your judgments?
After the case is over?
Right. What's the easiest way to get the money back from the people? Because I've been going through a loop and I
I
haven't.
mean, enforcing a money award in a judgment?
Yeah.
Well, there are a variety of options that are generally available to people. It's not really on tap to be covered tonight.
Okay.
But the types of general options are garnishments. You can go online and buy a Stevens Ness form.
Okay.
It's a self-help form. If you know where their bank is and they owe you $1,500, fill out that form, take it down to the bank, see what happens. The court generally doesn't want you coming back to the judge to say, hey, he owes me $1,500 and he hasn't paid me, unless it's child support, spousal support. Those are treated a little differently. But if they told you that, you know, they're keeping the car and therefore they owe you $2,000, I would say the most common sort of general practice is a garnishment. Anyone else? Rick, you got anything for me?
Hope you're covering it.
Bob?
No, you're doing great, man.
I had a whole list and I was checking them off as you went. I didn't have to ask them.
I've been doing this for way too long.
Well, if you guys don't have any more questions, we're going to thank Mr. Davis.
Thank you. Well done.